Supreme Court has recently clarified the extent of the president's powers to declare a state of emergency, including the authority to suspend or remove elected officials at sub-national levels. This landmark ruling has far-reaching implications for governance, separation of powers, and the balance between federal authority and state autonomy. Understanding the legal boundaries of executive action is critical for political leaders, legal practitioners, and citizens alike. Well, joining us now is lawyer and former CDHR President Malachy Ugwummadu. He will break down the Supreme Court ruling, examine its impact on presidential authority, and discuss the broader implications for Nigeria's democratic and constitutional framework. Good afternoon. Thank you so much for joining us on Newsday.
Thank you for the opportunity again.
So what do you make of this ruling by the Supreme Court? To what extent does it protect the autonomy of states within Nigeria's federal system?
Well, my take is that the Supreme Court had a very huge opportunity to bring further clarity to the constitutional framework and the ambivalence that we had suffered before the case, but didn't quite deal with it as expected. Like you did say in your intro, the powers of the state, the delineation of those powers, and the appropriation of those powers is what constitutionalism is all about. And therefore, where such a live case has come before the Supreme Court, we know it's a court of law and a policy court, but so much would have been achieved if the ambiguities, surrounding Section 308 in relation to the capacity of the president to dismantle democratic institutions would have been dealt with once and for all. That didn't quite happen. If at all, it created so much confusion, at least in the public, relating to how it navigated around it. But here is the point. The first thing is that judgment came a bit too late, about the time when the whole matter has become spent, using the legal terms as we choose to describe them, in the sense that a lot of water had passed under the bridge. The governor in question had even left the party in which he was before the situation arose and joined the ruling party. They've been return of the legislators and former, they moved to the ruling party and so on and so forth. So quite a lot happened, so much so that the facts leading up to the case was almost completely overtaken by events by the time the judgment was coming out. And by far more disturbing, at least from the point of view of the public, is that the question is now whether the president has an overbearing powers when you say that under the Constitution he has the discretion to use extraordinary powers to bring about peace within the state of an emergency. The big question is, does such extraordinary power does it include unlawful powers? The question and answer is simply
that
no.
is the big overhanging question. Also wondering what the role of judicial review is now. At what point can any aggrieved state or elected official successfully challenge the state of emergency declaration or the suspension measures, as it were, as an abuse of power or a politically motivated action?
And I think that was what the attorney generals of the respective states that went to court, starting with the attorney general of Adamawa State, about 10 of them sought to achieve. It is to find some clarity regarding the powers that the president has in the exercise of that extraordinary powers. And the big challenge that I saw was the court coming to the point that they lacked what we call local standing. If you say they lacked local standing, by implication you are saying your power to also determine the matter is divested. The reason being that the people who have approached you do not have the standing to come to you. Having said that, how then did you proceed to the merits of the matter and begin to make very far-reaching judgments that now leaves everyone even much more in a vulnerable state, so to speak, much more than we were before the matter came to court. And the point you raise is crucial, very germane. So what then would an aggrieved state, for instance, do in the event of such? Because indeed we have now seen that with or without those imminent dangers, those state of war, those conditions that are expressly described in the Constitution, when a president can invoke his powers under Section 308, if those situations did not arise, so what would the states do? They just simply fold their hands or throw their hands up in defeat. It didn't quite sit well with some of us, and I thought, with due respect, that this would have been a very big opportunity. It's not everything that must go through legislative amendments. Mm-hmm. The courts have, that's what you call case law, case review. The courts have ample opportunity to give effect to the intendment of the drafters of law. And it is when you have such live cases that they can now, seize that moment to bring clarity to what the legislatures may have intended.
So at this point now, is there a need, to amend the Constitution to further clarify emergency powers in light of this?
So if we lost the opportunity for a judicial review, a judicial case law that would properly situate this matter within some clarity, then the option we have is the constitutional amendment. And my position is well known. I have quarreled with the piecemeal constitutional amendments, so that what we can do is to take stock of all of these issues we are, recording from this Supreme Court judgment to very many others, particularly involved in the electoral processes, and collate them and come fresh with a new constitution.
And with all these interpretations, what specific amendment, in your opinion, should the National Assembly consider to clearly define the president's emergency powers and expressly protect elected state structures from unilateral federal interference?
Two come to my mind. The first is that the president shall, in no circumstance, arrogate to himself or have the power to dismantle democratic institutions. That's the first. And the Supreme Court said nothing really about that, even if it alluded to it. It should have no such power. The reason being that Section 1, Subsection 2 of the Constitution is express. It says no person, no authority shall have the right to take over the government of the Federal Republic of Nigeria or any part thereof. Rivers State is any part thereof. So when you take over the government of Rivers State in the name of a state of emergency, dismantle the democratically elected government, the governor, members of the State House of Assembly, and appoint a sole administrator. You have taken over the government of that part of Nigeria in a manner that is otherwise unprescribed in the Constitution. That is one. The other one is that the amendment must be clear as to what you mean by extraordinary measures. That clause in the Section 308, subsection 4, I suppose, has created some ambiguity that we are now posing the question, does extraordinary measure amount to unconstitutional measures? That's my question.
Lawyer Malachy Ugwummadu, thank you so much for joining us on Newsday.
Thank you. Thank you for the opportunity. Thank you.